Maryland has a moderately to heavily regulated breaking lease framework that varies significantly by jurisdiction, particularly between Montgomery County, Prince George's County, Baltimore City, and the rest of the state. The governing law is found in the Maryland Code, Real Property Article, Title 8, which covers landlord and tenant relations, along with general contract principles and local ordinances. If you're a landlord or tenant in Maryland, what rules apply depends partly on where your property is located. Let's start with the landlord's duty to mitigate damages. Maryland law requires landlords to make reasonable efforts to re-rent a unit when a tenant breaks a lease and vacates. This duty is established through Maryland case law and is well recognized by the state's courts. The landlord cannot leave the unit vacant and hold the departing tenant liable for the full remaining rent without making genuine efforts to find a replacement. The landlord must take reasonable steps: advertising, showing the unit, and accepting a qualified applicant. The departing tenant's liability is limited to rent during the vacancy period, plus reasonable re-rental costs. If the landlord fails to mitigate, the departing tenant's liability is reduced by the rent the landlord could have collected through reasonable efforts. Maryland courts evaluate mitigation reasonableness based on the specific circumstances: local market conditions, property condition, the landlord's typical marketing practices, and the time of year. In Maryland's generally strong rental market, particularly in the D.C. suburbs and Baltimore metro, landlords can typically re-rent within a reasonable time frame. Early termination clauses are generally enforceable in Maryland if they are reasonable. Maryland's Consumer Protection Act provides a basis for challenging lease provisions that are unfair or deceptive, including early termination fees that bear no reasonable relationship to the landlord's actual damages. A fee of 1 to 2 months' rent with reasonable notice is typical and generally enforceable. Excessive fees face challenge. Maryland has a specific provision regarding liquidated damages in residential leases. Under Real Property Section 8207, a lease may include a liquidated damages provision, but the amount must be reasonable and not punitive. Maryland courts will not enforce a liquidated damages clause that functions as a penalty. The amount must bear a reasonable relationship to the anticipated or actual damages. Military members have the right to break a lease under the SCRA. Maryland has an enormous military and defense population. Fort Meade, home to the NSA and U.S. Cyber Command, is one of the largest intelligence installations on the East Coast. Joint Base Andrews in Prince George's County, Aberdeen Proving Ground in Harford County, the Naval Academy in Annapolis, and Patuxent River Naval Air Station in St. Mary's County all generate massive military and defense-related rental demand. SCRA lease terminations are extremely common throughout Maryland. Active duty service members with qualifying orders can terminate by providing written notice and a copy of the orders. The lease terminates 30 days after the next rent due date. No early termination fee or penalty applies. Maryland landlords, particularly those in Anne Arundel County, Howard County, and Prince George's County near major installations, should have SCRA processing as a core competency. Maryland has enacted protections for victims of domestic violence that allow early lease termination. Under Real Property Section 8-5A02 and following, a tenant who is a victim of domestic violence can terminate the lease by providing written notice and documentation to the landlord. The qualifying documentation must include a copy of a valid protective order, either temporary or final, or a copy of a police report filed within the preceding 60 days, documenting the domestic violence. The tenant must provide at least 30 days written notice before the termination date. When a domestic violence victim terminates under this provision, the tenant is responsible for rent through the termination date, but is not liable for rent for the remainder of the lease term. The landlord cannot charge an early termination fee. The security deposit is handled according to standard rules, returned within 45 days. Maryland's provision includes protections for co-tenants. If the victim and the perpetrator are both on the lease, the victim can terminate their individual obligation. The landlord can then pursue enforcement against the remaining tenant if they violate the lease or the protective order. Tenants in Maryland may break a lease if the landlord fails to maintain habitable conditions. Under Real Property Section 8-11, the landlord has a duty to repair and eliminate conditions that constitute a substantial and serious threat to the life, health, or safety of occupants. Maryland's habitability framework includes a rent escrow process, one of the more developed rent escrow systems in the country. Under Section 8-11, if the landlord fails to address serious habitability deficiencies, the tenant can petition the district court to place the rent in escrow. The court can then order repairs, reduce the rent, terminate the lease, or take other appropriate action. If the landlord fails to comply with a court order to repair, the court can terminate the lease, relieving the tenant of further obligation. The rent escrow process gives Maryland tenants a structured path from habitability complaint to lease termination, with court oversight at every step. Tenants who use the rent escrow process have strong legal protection because the court has reviewed the conditions and made findings before the lease is terminated. Maryland also recognizes constructive eviction. If the landlord's failure to maintain the property or affirmative actions, shutting off utilities, failing to address dangerous conditions, render the unit uninhabitable, the tenant can treat the lease as terminated. Montgomery County adds significant complexity. Montgomery County has the most regulated rental environment in Maryland, with a fair chance housing ordinance, source of income protections, and other tenant provisions that may affect how broken leases are processed. Montgomery County's Office of Landlord-Tenant Affairs provides mediation and dispute resolution services for landlord-tenant issues, including broken leases. Landlords in Montgomery County should be aware that the county's active regulatory infrastructure means disputes are more likely to be formally reviewed. Prince George's County has also been active in tenant protection discussions. Baltimore City has its own set of tenant protections and an active tenant advocacy community. Landlords in Maryland's major jurisdictions should verify current local requirements. Maryland's lead paint law is relevant to the breaking lease context. Under the Maryland Lead Paint Poisoning Prevention Act, landlords who own pre-1978 properties must comply with lead paint registration and risk reduction requirements. If a tenant discovers lead paint hazards, particularly in a unit with young children, and the landlord fails to remediate, the tenant may have strong grounds for lease termination based on habitability. Lead paint violations are taken extremely seriously in Maryland, and the penalties for non-compliance extend well beyond the lease termination context. From a practical standpoint, Maryland's rental market is shaped by proximity to Washington, D.C. and the Baltimore Metro, creating one of the most economically diverse markets in the country within a relatively small geographic area. The D.C. suburbs, Montgomery County, Prince George's County, and parts of Howard County and Frederick County have extremely strong rental markets driven by federal government employment, defense contractors, technology, and healthcare. When a tenant breaks a lease in the D.C. suburbs, the landlord can typically re-rent within 2 to 4 weeks, often faster in prime areas. The steady influx of government employees, contractors, and military personnel creates deep demand. Fort Meade's massive workforce, military, civilian intelligence, and contractor generates enormous rental demand in Anne Arundel and Howard counties. The regular rotation of military and intelligence personnel creates constant SCRA terminations and general lease turnover. Landlords near Fort Meade should expect and plan for frequent lease breaks. The Baltimore Metro, including Baltimore City, Baltimore County, Anne Arundel County, and Harford County, has a more varied market. Revitalized Baltimore neighborhoods, Canton, Fells Point, Federal Hill, Harbor East, have strong demand with quick re-rental. Other parts of the city have softer demand with longer vacancy periods. Frederick has a growing market driven by Fort Detrick and commuters to both Baltimore and D.C. Hagerstown and Western Maryland have more affordable markets with moderate demand. The Eastern Shore has smaller markets influenced by agriculture and seasonal tourism. Ocean City has seasonal dynamics. College Park, home to the University of Maryland, has a tight student market. Towson, Salisbury, and other college communities have seasonal student demand. One best practice for Maryland landlords: determine which jurisdiction your property is in and understand the specific local requirements. Montgomery County, Prince George's County, Baltimore City, and other jurisdictions have different regulatory environments. Build your breaking lease procedures around the most restrictive requirements applicable to each property. Another best practice: begin re-rental efforts immediately and document every step. Maryland's mitigation duty is well established, and the state's active court system and tenant advocacy organizations mean that disputes are likely to be formally reviewed. Thorough documentation of your re-rental efforts, listing dates, advertising channels, showings, applications received, and acceptance dates establishes your compliance with the mitigation duty. A third best practice: understand Maryland's rent escrow process under Section 18-2111. If a tenant files a rent escrow petition because of habitability complaints, respond immediately and comprehensively. A court finding of habitability deficiency followed by a failure to repair can lead to court-ordered lease termination, with the landlord bearing all costs. Addressing habitability issues promptly prevents the escalation to rent escrow and avoids the risk of a broken lease on the court's terms rather than yours. Maryland requires landlords to return the security deposit within 45 days of the tenant vacating. The deposit is limited to 2 months' rent. The landlord must provide an itemized list of deductions. If the landlord fails to return the deposit within 45 days, the landlord may forfeit the right to retain any portion and may be liable for up to 3 times the amount wrongfully withheld plus attorney's fees. These rules apply whether the departure is a normal move-out or a broken lease. For the complete guide to Maryland breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.